Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. All right, one of the things we were getting into, we were talking with that last caller about with regard to bank advice, you know, they're trying to help, all right? You go in, you're talking to someone there, they're not necessarily qualified about estate planning or what the different, you know, what this may lead to. So you say to them, I'm concerned about if something happens to me, I want to make sure it's oh, well, we'll just put it in joint ownership. When they don't recognize that that puts that asset all of a sudden at risk, or the potential, what happens if that person you put on a joint, what if they pass away? Then what happens? None of these questions get answered. And this is where estate planning, though, we do just that. So we can have, and here's another one for you. What happens if you become incapacitated, all right, and you're not able to take care of? What is that, you know, that joint ownership thing is, you know, can help them if they access things, but if they're not able to, what if they became incapacitated? I mean, there's just all these different what if scenarios that are not addressed, and that's where a trust can address all of that. And it says, you know, if this, the language is put in a trust when drafted well, okay? So this is the other part. I say that because I've seen both with wills and trusts about people trying to draft their own, trying to write their own will or write their own trust, and we're going to, if given time, we're going to delve into that a little bit more. But that's why that caveat. If it's done correctly, then that language is going to be there that's going to speak to those things of, you know, if the person you want to take care of things can't, then who's the backup? If the person that you're leaving things all of a sudden is they predeceased, where does that money go after in that situation? You know, all of these things are taken into consideration. If you become incapacitated, who do you want taking care of your stuff for you? Who do you want paying your bills? Who do you want making medical decisions? All of those things get handled when you have a good plan done. All right, we're going to go to the phone, and this is Sean. Sean, welcome to the Retirement Report.
Good morning.
Good morning.
Hank, I have a small question, maybe a two-pointed question at the end.
Okay.
But what if you are in a family aired property that has been without shared through the family, and one of the main heirs has passed away?
Okay.
And you have like a third from your sister, your brother, whatever, or in third with the heirs.
Okay.
Do I need to, as an heir, go back to probate court, or am I straight, or well, second point of question, can I do a force of sale my end just to get my name off of it?
Right. Great questions. You know, so you've got a property that you've inherited, and it may have been to your parent, and they predeceased, and now it's passed on to their children, their share. That kind of a situation, right?
I'm going to hang up so you can tell me.
Okay. So this is a great question about how many times with regard this, especially wills, you can end up with multiple owners, sometimes different generations, different percentages, and different ultimate goals of what they want to do with that property.
Yeah, and we see that a lot, and that just comes from a failure to plan, or maybe making a plan but doing it with somebody who's inexperienced and doesn't really think about, you know, what's a 20-year, what can go wrong, all the what ifs. That's why you want to work with someone who actually has a lot of experience in estate planning, wills and trusts, and probate. Unfortunately, in your situation, it sounds like I didn't understand if you were wanting to just get off of it or if you were wanting to try and force a sale. You can force a sale. The courts get involved to do that. If you're just wanting to get out of it, then you can quitclaim your interest to one or all of them. That's up to you. I wouldn't do that before talking to somebody to see. I mean, I would at least get an appraisal of the property, find out what it's worth. You don't want to give up something that's worth more than you think it is.
This is another area, in fact, exactly right. The great advice is that you want to start with getting an appraisal of the property. So you want to know what the value is and what your share then of that property represents in terms of money. Now, having run into these kind of things before, sometimes you'll get, maybe there's one or two people that really want to hold on to that property. They want to own it, and so they could buy out your interest, and you can be able to quick claim your interest over to them for whatever you've arrived at as far as a fair price. Ideally, that would be the place I would go first. us is getting a consensus, if possible, of what people want. And maybe there are a lot of people that want to sell theirs. Maybe they'd be happy to do that, and then everybody just gets together and gets it on the market and affects the sale and divvies up the proceeds accordingly. If there is one or two people that would like to hold on to the property, then maybe they can go out and get financing and buy out the other people so that they can own the property. So there are a lot of different ways that you can do it. Now, if everybody's fighting and fussing and nobody can agree on anything, well, then there's your last resort. Maybe you need to go to court and say, hey, we can't agree and we need to just, I want out, so therefore I want to be bought out. Either one of these people that don't want to have to buy it, or we have to sell it and do it that way. And if it's a forced sale, well, any of the other people can be one of the buyers in that situation as well.
Right.
It still retains the ability to do that. So those are all ways that can get handled. Planning may have come into play there in terms of dictating or saying this is what I want to have happen. In a trust document, we try to ask a lot of what if questions when we sit down and do planning. What if this happens, or what if that happens, and so we can get that feedback of what the person would like to have happen, and then we can put language in. This is where Jack comes in, putting language in the trust that makes sure that those things in fact happen.
Yeah, and the legal term is called a partition sale. If you, and we've seen this unfortunately a lot of times, where you got 3 or 4 or 5 or 6 heirs who are all on this property, and 75% of them want to sell, the other 2 don't, and they refuse to cooperate or even communicate with anyone. Mm-hmm. Unfortunately, in those cases, about your only resort is going to be to go to court and ask for what's called a partition sale. That doesn't mean that those other 2 that are holding out can't end up being the owner, but the court will force them to either pony up and buy everybody else out or go along with the sale.
So there's a lot of ways that this can be done. All right, we're going to take, again, time for a break. When we come back, we'll try to get into a little bit more here for you. First, a break, right? And then we'll be right back on the Retirement Report.
The time has come to enjoy your golden years, but have you saved enough?
I'm Hank Parrott. Don't just survive in retirement, thrive. Call me today at